Hello, everyone. It's good to be with you this afternoon to share with you our first response to this very important judgment that we received today in the case of Christian Hacking, who works with Centre for Bioethical Reform UK. This young man is part of an amazing group that have an education project that goes around the country showing pictures of the unborn child in the womb. Sometimes those are pictures of the live preborn child, sometimes of what a child that has been aborted looks like. And that was one of the images that was being shown on the 3rd of October last year in 2019. And it was part of a Stop Stella campaign. What it was, the Stop Stella campaign, was Stella Creasy is an MP who is persistently and avidly seeking to liberalise abortion. She has been part of a group of MPs that have sought to liberalise the abortion laws in Northern Ireland. So that's really without proper democratic procedure, and also here to keep on pushing on to liberalise the time limits. And the picture that CBR was showing that day was a picture of an aborted child at 24 weeks. And the caption was, "Your MP, the MP in Walthamstow, Stella Creasy, is seeking to make this legal." And Christian Hacking was issued with a community protection notice, which meant that he had to take down his banners. And that particular notice was deemed in the end, and it was admitted in court, in the courtroom, that had been issued in a way that was in fact against the law, that hadn't legally been issued. However, in the judgment, this is one of the things that was talked about. First of all, the CPM in paragraph 6 of the judgment, it says this: the CPN appealed in this case was issued to Christian Hacking by Philip Connor at midday on the 3rd of October 2020, pursuant to its powers under Section 43 of the Anti-Social Behaviour, Crime and Policing Act. The conduct complained of as having a detrimental effect on the quality of life of those in the locality, being persistent and continuing in nature, and unreasonable in displaying large images of unborn fetuses and or aborted fetuses, which have caused or are likely to cause distress and or alarm to members of the public. A warning had been issued 15 minutes earlier to Christian by Brian Nish. And that community protection notice order required that Christian was to remove from public view the images of large unborn fetuses and or aborted fetuses, and that Christian would not be permitted to return to the area in possession of large images of unborn or aborted fetuses. And so that is what was actually protested by the local authority at that particular time. So I wonder whether I can bring in Roger Kiska, who's part of the Christian Legal Centre team here. So Roger, the community protection notice was issued. The displays were taken down really by forcibly. Some members of the public have passed by and had said that they were distressed by those images. But I think it's also right to say that there were other members of the public who were grateful for the fact that those images were out there on the ground. What does all of this mean for expressive rights, and what does this judgment say with regard to expressive rights?
Well, first of all, before we get into the issue of expressive rights, it's important to note that the court, at the outset of the judgment, suggests that this case has nothing to do with abortion.
Yes, that's right.
I think that that's absolutely false. This case has everything to do about abortion, the right to protest it, but also the fact that we've had more than 9 million abortions in the United Kingdom. So this is a fundamental issue of public concern. And if we look at the case law on this, the previous case law on this, The belief that life begins from conception and the right to protest abortion is a belief protected under Article 9 of the court. Now, this judge said that Article 9 would be dealt with just as Article 10 was dealt with. It wasn't dealt with separately, and I find that to be a significant flaw in the judgment because it's a different corpus of jurisprudence altogether. But the judge did find that the protest in this case was political speech and therefore had a higher level of scrutiny, strict scrutiny, and that in order for the interference, the order to be lawful, it had to be prescribed by law, which both parties suggested it was. It had to pursue a legitimate aim, which the local authorities suggested was the protection of health and morals, and the fact that they found several of the witnesses had suffered some kind of emotional distress from viewing the images. And third, that it must be necessary in a democratic society. And that third point is the point of contention. And we've seen in other jurisdictions in Europe. I'm speaking to you from my home in the Slovak Republic, where I've been going through the quarantine. Our constitutional court here, even though we weren't all that long ago under socialism, had this exact same case before them. It was CBR, it was the same image. And not only did they find that it was a lawful form of political speech, but CBR was given damages in the case when police stopped their freedom to protest. So we have strong jurisprudence coming from other jurisdictions in Europe. We have strong jurisprudence coming from the European Court of Human Rights in cases involving the right to abortion protest, the most recent being Annan v. Germany, which was a similar case, which was contentious. It was a case where protesters or people who were ideologically opposed to abortion were offended. Yet the court held that the speech was so important that we have to allow for offense. And the final point on this I'd like to make is that the UN Human Rights Committee has recently been trying to put together a commentary on the issue of freedom of protest, and their suggestion is we should have more freedom and not less freedom. So if we are looking at the fact that we've had over 9 million abortions in the United Kingdom, the display of an image like this only adds to the public debate. Now we have the government itself putting cancerous images, horrible images on cigarette packaging that anyone who goes through a store.
Perhaps I can come in on that a little bit, Roger, then as well, because it's right that the judge in this case, he talked, didn't he, about the cancer images on the back of packets, or recognizing those. But in the paragraph 36, we've had the detrimental effect. And there he writes this: there is no doubt in my mind the conduct, by which I mean the display of the 42-week dead fetus, had a detrimental effect on the quality of life of some, though by no means all, and he makes that clear, of the people in the locality. In my findings above, I record this image is correctly described variously as graphic, sickening, disturbing, anxiety-inducing, frightening, and horrific. The appellant's example, if something is lawful, it cannot be detrimental, is a non sequitur. The simple example in the statutory guidance of a baby crying through the night exposes the flaw in the argument. It's not unlawful, but could have a detrimental effect on the neighbours who are kept awake. What do you think the judge is really trying to getting to at that point? And isn't it interesting that he actually records that the image of the aborted fetus is graphic, upsetting, sickening, disturbing, anxiety-inducing, frightening, and horrific, and yet the MP in that constituency is wanting for this procedure to be extended beyond the current time limits in our country and beyond, in fact. So what do you think of the argument that the judge is making in that particular paragraph?
I think it's wholly deficient. The issue of a crying baby, and it's ironic that he uses the crying baby.
It is.
The issue of a crying baby versus the death of 9 million unborn children and late-term abortion, that's a pretty stark contrast. And, when we're looking at political speech, we have to weigh the seriousness of the issue and the importance of it to public discourse. Now, this issue You have a lot of contention on both sides, but it is clearly an issue that needs to be discussed. And part of that is allowing uncomfortable images because they tell an uncomfortable truth. That image wasn't a mock-up; it was the real deal. That, as you said, it is an irony beyond ironies that the image is somehow worse than the reality.
Yes, I mean, isn't that absolutely extraordinary? And as we are here doing this live stream from two different countries, as you say, locked down, we are locked down, are we not? Across nations, and if we think because of the reality of death that's within the culture, but for not yet 30,000 deaths, and we don't diminish the seriousness of that with regard to coronavirus in this country, but and that is very serious. And of course, in some ways, it's a different thing. But the reality is that every day in the United Kingdom, we have 850 abortions. We have had, since the passing of the Act, as you say, probably more than 9 million now. We have 200,000 abortions going on every single year. And yet to try to address that reality is shut down as a proportionate measure because it distresses the public. So it's something to think about, isn't it? And this, there's a sense in which now this case will be appealed. I know that CBR is wanting to appeal it, and we will support them in that. It's going to be important, isn't it? Because of course, the contending for what the truth of what abortion is and being free to speak about that. Tell us why you think it's important, Roger, in terms of continuing to appeal.
Well, first of all, images tell a truth that words sometimes can't express. So when we look at the Holocaust, one of the most powerful ways we have told the world about the Holocaust is through the images of those who died as a result, of the emaciated bodies, of the mass graves. So images have power. If we go back in time, one of the images that helped change the hearts and minds of the United Kingdom about slavery was a painting about slaves being thrown over the ship, as mere chattel. So the reality is this ability to show images which reflect a truth is an important function of a democratic society. So I think we need to appeal this. And I read one comment where it was suggested that CBR or anyone in general was no longer allowed to show this image. That's absolutely false. This is a very fact-specific case dealing with the showing of an image in that particular square on a busy day in that particular dimension. So this has nothing to do with the right to show the image. It's a fact-specific case.
Yes, I think on that, let me say the image that is quite interesting because the notice itself was talking about not being able to show aborted or unaborted fetuses in the square on that day, but they said they could continue to show their videos and their leaflets and so on. But you're quite right, Roger, that this is specific to that situation in terms of what it has prohibited, what the notice prohibited. So it's not a general blanket ruling in that regard, but it's more significant in terms of contending for the freedom to express this in the public space. And it's why it's so important that this judgment is appealed. And that's something that I know that those working at the Christian Legal Centre, even now, will be beginning to prepare in order to take this forward. Be great if Roger could come back onto the screen if possible. In paragraph 42 of the judgment, the judge said this: I'm satisfied that the notice was issued by Philip Connor in pursuance of the legitimate aims he described: prevention of disorder and protection of the health of others affected negatively by the conduct. While the presence of the police, and I think what was also interesting that day was that the police did not want to intervene. They saw this as a right for CBR to protest abortion. But there had been a political situation whipped up by the MP Stella Creasy at that time, by the council, where she was saying that the very showing of this image and the exposing of her campaign amounted to harassment. So we saw that. So it was interesting that it was the council that was on the front foot with regard to this. The police were there, but not intervening, because the truth is that when it comes to Centre for Bioethical Reform, they would never do violence. There never has been violence. All they want to expose is the violence against the unborn children. So, and this notice actually being issued in a way that was unlawful, I think, is also important to note at the time, because the police hadn't intervened. And that, again, that is something that the judge doesn't take particular issue with.
I would note that the fact that the judge found the actions in giving the order sort of a legitimate aim is nearly irrelevant. The issue is proportionality, and the question of whether doing so is necessary in a democratic society. That's the standard for Article 10 of the Convention. And, differing minds can come to different conclusions on that. To accept the court's ruling, you have to accept a whole lot of presuppositions, including the belief that every witness was there in good faith, that they weren't opponents of abortion, that Stella Creasy had nothing to do with the issue being, the order being given. And those are very, to me, difficult presuppositions to accept in the first place. So I think it's very easy for any judge to come to a differing opinion on the same facts, which is why it needs to be appealed, because what's at stake here is freedom of protest, freedom of expression, and not just that, but the freedom to protest is very, very crucial right, and that is the right to life.
Well, thanks so much for Roger from the Christian Legal Centre for joining me, Andrea Williams, Chief Executive of the Christian Legal Centre, here this afternoon. Please continue to stand with us as we continue to contend for the unborn children in our society, but also for our freedom to speak and to expose the reality of abortion, to contend in the courts on this, to contend for truth, to contend for justice, to contend for reality, to contend for protection. So thanks for being with us. Bye for now.